Okay, can you hear me now?
Yep.
Okay.
So Mike, Office 365 just updated on my computer, and Jonathan and I cannot figure out how to turn off the voice, and I can't turn off the voice on my PowerPoint without muting me on Zoom.
Okay.
Hi, Diane. Everyone, we are live streaming at this point, just so you're aware.
Happy New Year, Diane.
Happy New Year.
Oh, maybe Andy. Hey, Andy, do you think my Office 365 just updated, and as a result, Jonathan and I have been trying to troubleshoot it. It's recording my voice. I cannot put it on mute because then you couldn't hear me. Could you share your screen with the appropriate slideshow when it's time?
I'm trying to transfer it now to the computer.
Okay.
Okay. I might be able to, Barb. I just have to go to the email that was sent out this afternoon. I'm remote right now.
Andy, I can also do it. I just need to find that same email then.
It was sent this afternoon by Carmen.
Okay.
Let's see if I can find it.
I've got it, Andy. I can do it.
Okay, thank you, John.
Just please tell me when it's time to start it. Barb, is that okay?
Yep. Nina's going first. So Andy, what are you and your wife going to do with a quiet house now?
It's definitely quiet. The dog will get even more attention, I guess.
Well, my daughter, she just picked up her dog having come back from Costa Rica, but then she just dropped it off again. We like rent a dog.
It's kind of like having a small kid in the house.
Right.
Hey, Jordan, are you there?
He's on mute.
Yeah, I just have a quick question. I want to make sure.
John, you're clear that Nina's got her presentation that she'll be sharing, correct?
Yeah, I've got, this is the presentation I'm looking at. Is this the one I'm sharing when it's time?
Yes, but
That's
that time is
after
not
Nina.
now.
Okay. I just want to make sure that's the right one.
Yep.
Correct. Yep. And Nina's
Hi.
got her
Yeah, sorry. The one I
slideshow.
have will be on my computer because then I could,
Yep.
yeah, thanks. And I could share with everyone after. I didn't want to distract people. Hey, Cindy. Hey, everyone, I can see.
Wasn't sure
Jordan,
if everyone was done talking. Hello, everybody.
Sorry.
Hello.
Are you
Hey,
all
Jordan,
healed up for me?
are you able to unmute Jordan? Or is your computer working?
I don't see Jordan on there. Do you?
He's there. He's just.
Oh, wait, can you hear me?
Yes,
Oh, I
sir.
hear- Yep.
Okay. I have to
I just wanna
unmute the
make sure
phone
you're
and the
working.
computer.
Okay, cool.
Yes, thank you.
Hmm. One second.
How's the new work going, Jordan?
So far, so good. Lots of Zoom meetings,
Is it?
but mostly Microsoft Teams. So I'm more used to those settings.
You guys been watching the crazy news? Isn't it ridiculous? We live in a screwed up world right now.
That's for sure.
I know. It's like, come on, people.
Historic and not a good way.
I know. Makes you really look at how immature our society is. I mean, crazy.
Well, they've been conned from the beginning.
Yeah.
I think public education too, about our government and what it stands for or supposed to stand for. I think education is lacking.
Cindy, is your hip all healed up now?
Oh, gosh, no. It's about 3 months
Oh,
of healing because it's your femur. So it's my femur is what it is. So they put pins in it and it just takes a long time for that bone to heal.
That's hard. Are you able to walk?
Yeah, I walk and everything. By the end of the day, I'm limping on it pretty good. But physical
Yeah.
therapy is supposed to help that. But the way the highway has been, I never can make it to physical therapy. It takes me an hour and a half to get home from
God.
work every day. It's been ridiculous. Yeah. I don't know what was going on. What was it, Monday night? There wasn't any construction, was there, Andy? Monday night? Because it took, I bet, an hour and a half to come down from the ski area. And all of a sudden you hit Idaho Springs and traffic was fine. But from Georgetown to Idaho Springs, I bet you it took an hour.
oh my God.
It was ridiculous.
Yeah, there's
Yeah.
not supposed to be any more construction on the main line until
Yeah.
when they do the top lift of paving. There's construction offline and maybe in the express lanes, but that's about it, supposedly.
Yeah. I don't know what was going on Monday night. And then, of course, that week before Christmas, gosh, I think it was an hour and a half one night, hour and 40 minutes another night, 2 hours another night. Yeah.
Wow.
Pisses you off.
It's crazy.
I've seen quite a few skiers going up and down the road during the weekday even. So I think a lot of people are trying to get up there whenever they can.
Yeah. Yeah. We had a good crowd today. I mean, we had 4 inches of snow, and I think that just because we've really not had a lot of snow. I think we're at 78 inches and we're usually at about 160
Wow.
last year. So yeah, it hasn't been, but crowds have been pretty good. Yeah. People are definitely going skiing. All right. Who are we waiting on? This is just a work session, right? Yeah. So who's going to start? I kind of thought, Nina, you and Andy take charge and run it. Go with it.
Sure, I'll kick it off. There are 2 purposes for tonight's meeting. One is to receive the periodic training from our city attorney, Nina Williams. And she'll go first. She's got a slideshow that she'll be presenting here shortly. And she did provide some information in the agenda packet, some background information. And then the second part of the meeting will be a presentation by Barb, our community development planner, mainly focusing on mainly one policy issue, and that is whether or not
Where are you?
wants to consider having
Okay. I can see you. Bye.
whether or not the Planning Commission wants to consider having work sessions before formal application submittal on a project. So that'll be the main item. And then we want to also touch on the topic of running rezoning and a final development plan concurrently. We recently had a project that went concurrently. We've had, well, actually had a couple in the last several years. And whether, just about that topic and how we should manage that if a project involves both a rezoning and along with a final development plan. So that's the main the main purposes of the meeting tonight, and then anything else that planning commission would like to talk policy-wise. We've got both the city attorney and the planner here, as well as city staff, to talk with planning commission. With that, unless you have anything else, Cindy, I would say we could go right into the.
Oh, no, go ahead, you guys.
Okay. Hi, everyone. There was an outline in the packet, which says training and refresher, and that's more detailed than the PowerPoint I'm going to show, but I also will then share the PowerPoint with anyone. Well, I guess I'll send it to everybody. I can just share the screen myself. So I'm going to share it and then I'll run the PowerPoint. And let's see, start slideshow. We can start. All right. So this is a football. This is from 1961. Vince Lombardi, he was the coach of the Packers, and in 1960 they had lost the championship game, and he literally, this happened. He held up this football and said, "This is a football. We're going to start from the basics. I'm not taking anything for granted. We're going to go to the elements and start from there, because you build your foundation." So I know a lot of you are very experienced, and we're not going to go long into the fundamentals, but we're going to start with the basics and have a groundwork for everyone, so we're all on the same page, literally starting with the football. So the first thing is quasi-judicial and ex parte, or demystifying Latin terminology. I don't like that we all use, or I guess lawyers use Latin terminology, but so it is. I can't change the world, but you hear this a lot of times, especially in planning commission. Most of what you do is quasi-judicial, and we're always cautioning. And I thought, let me just explain what that is. What's the difference between quasi-judicial and legislative? So quasi-judicial in Latin means kind of judicial, not a direct translation, but so judicial means you're acting like the judge. So that's why it's so important. We'll go into that later, but it's a narrow application. It doesn't make the policy. It applies the policy that you've already created in your land use regulations to a specific set of property, either a specific set of property or somebody's usually set of property rights. So land use approvals, licensing hearings, nuisance abatement, you guys will do the land use approvals. Legislative is when you did create your land use regulations, or when we just recommended amendment for the short-term rentals, those type of ordinances that apply to the whole city or one district of the city, that's legislative. So think of, even if we don't think of like the words, it's more, if we're affecting one person or one business or a limited group of people or businesses' property rights, that's important to have extra precautions to make sure for fairness. So impartiality is a standard. So there's 3 ways that a hearing could be not partial, or you as a commissioner could maybe not apply impartiality. So the first thing is ex parte, again, another Latin term. So we hear that a lot. If anyone ever has watched Law and Order, when the prosecutor and the criminal attorney go into chambers or sidebar, they both have to talk to the judge at the same time usually. That's because the judge can't talk to just the prosecutor or just the criminal lawyer. So that's just maybe an example that you could think of, that since you're acting as a judge, you have to make sure that you don't talk to one side or the other, because it's only right for the fairness of the community and for the property right owner that they see all that you are basing your decision on, not these side conversations. So I put an example: a neighbor comes up to you at Smoking Yards to hope everyone had dinner, otherwise I get hungry, to express their concern with the development application. You have to say, as a planning commissioner, I'm sorry, this is for your fairness, either write an email to the city clerk or come to the hearing. Now it would be virtually, and make sure that your opinion is heard. And you could say, it's to make sure that the whole commission hears at the same time. Or you could always say the lawyer told you, but it's better to explain why the fairness. And then also why a lot of times I've realized that when people complain about ex parte communication, they don't really care about that part that the rest of the commission. It's more, I think a better way to say is if you had an application for your property, for a variance or whatever you want to do on your home residential property, you would want those same fair procedures applied to you. So that sometimes that gets through to people. Another way you could not be impartial is if you have prejudgment or bias. So you've spoken out, there's too much affordable housing, I'll be against any affordable housing. As a planning commissioner, you don't want to say that because then you probably shouldn't be considering any application that relates to affordable housing because you've already shown that you can't hear what's happening in front of you at the hearing, which is where you're supposed to consider all the facts and all the evidence. You've already made your mind up. No matter what, that person has no chance with you, and that's not fair to them because you already made your mind up on the issue. And then conflict of interest is an example is a financial benefit. I put your spouse as a manager at Safeway. That's very general, but maybe if it's an immediate family member or yourself is going to benefit financially in some way, then that's not. Well, we'll see what you should do. The next question, how do you cure? So if one of those three things has existed, either, the ex parte, the prejudgment bias, the conflict of interest, and at the bottom, I say, when in doubt, ask your city attorneys. That's what most of you have done. You come to me before the meeting. Hopefully we get back to that soon. Or you call me or you email me and you ask, and you always should err on the side of asking because you all do already. You want to make sure you're doing the right thing, your fairness. So when you ask me, there's two ways. You can either disclose on the record if you feel you can still make a fair decision. There's some circumstances, well, even if you disclose, you probably still should recuse. So either disclose on the record, for example, the smoking. My neighbor came up to me at Smoking Yards and I told him to stop talking, and I know that I can still make a fair decision, but you want to just make sure it's on the record for everyone to hear. The recusal is something, if you have a direct financial impact, or if you have written all over Facebook, for example, that you're against any development on Minor Street, you probably should recuse yourself. So these are the questions that I will help ask with you that I have asked. And then there's different levels of recusal. Either you just don't even come to the hearing, leave the room, or in some cases, if we feel like you're not going to unduly influence the rest of the commission, you can be there, but you can't participate or vote. That would be unfair. Why is this also important? The United States Constitution, it really does go to that. It's not just us being annoying. It's someone's right of property, in this case, cannot be amended or affected without due process of law. So we hear that word due process a lot. That means fairness, justice. I made up a word, justice. Everyone with an interest in the case, so it should hear the same evidence at the same time. So again, back to you're a judge. The judge, you only could consider what is in front of you, and it's only fair that everyone views what you are considering. So that would be the record, what we call, that's like the packet, any letters, any testimony, the staff report. So everyone in the community and the property owner can see this is what they're making their decision on. It's all out in the open. It ensures fair hearing, that you're unbiased, and that you all have the same benefit. And the reason why lawyers are involved, not only because we want due process for everyone, which is the most important, we also want to make sure that there's no liability, litigation. If decisions are unfair, not only could they be appealed and then they have no stand, then they don't stick, let's say, but also it could be a huge liability for the city in terms of a lawsuit and financial impact. I'm going to send this to you guys. Carmen and I wrote this article, which kind of explains it in a cute way. So I just included that to remember to send this to you guys. So does anyone have questions about the Quasi-Judicial General, or should I just go through and wait for questions? I forgot to ask. I guess if you do, you can tell me now. I won't, because I won't see any questions in the chat box. Okay. So open meetings law. This is another, again, fundamental to football that you probably have heard. If, for example, maybe a lawyer has jumped in when you've written an email, a group email, and don't reply all. So open meetings law is that any meeting of the council or the planning commission must be open to the public so everyone can view the decisions you're making, and full and timely notice, which usually is 24 hours. So what is a meeting? It's not just, as we know now with COVID, it's not just in person. It's this Zoom meeting, but it's also texting, a group text. It's emails. It could be the Zoom chat box, which we've hopefully we're going to talk about that later, not, or maybe just in the bottom, not to engage in. So the reason why that's considered a meeting is because so an elected official or an appointed official isn't being cute, right? Oh, we didn't talk during the meeting, but we emailed about it. You know, everyone has the right, even if it's a legislative or any kind of meeting, the public has a right to see how their elected officials and appointed officials are making decisions. So that's why this exists. So it's very hard to have a group text or an email with the public participating. So we just don't do it, or group texts or any kind of messaging, any electronic, any whatever. And then it's not just how it exists, it's what you're discussing. So this, a meeting for the open meetings law for this fairness is when public business is being discussed. Any rule, regulation, formal action either being enacted or recommended, which you guys usually recommend. But that's still public business that your citizens have a right to see how you're making your decisions. It's also, it's not a chance meeting or a social gathering. So if you have a holiday party, make sure you don't talk public business, but, or maybe three of you have your kids are in the Boy Scouts or something. You don't have to notice that. You just don't talk about public business. And that's written to make sure to protect you guys. It's not like you walking around with a wall around you that you can't talk to people. So then I just wrote, let's think about what about texting each other during a meeting or messaging in the Zoom. We do Zoom here, so Zoom chat box. Either one of you to each other, that's not, the public's not reading that, so so that's not appropriate. Or same thing with your texting each other. If you're texting a developer or the applicant, obviously that's ex parte, and then the entire, instead of texting or messaging, you should be saying it verbally so everyone could hear. These are taped and we have the minutes. So that's important to know, and that's why it relates to open meetings law and just, again, fairness. So public hearing, in the packet, I had sent just a piece of one sheet of paper. I don't know why I'm showing it to you, but the order of a public hearing. I think it's good to have, I know Cindy usually has it, some kind of order in front of her, the presiding or who's ever presiding in Cindy's absence, Chairman Olson, sorry. So this is a typical outline. It could be moved around a little bit, but most of these elements should be in every public hearing. So you open it, the city staff makes the report, the applicant makes their presentation. They're the ones requesting, they need to seek the opportunity. Public comment, in most public hearings, you always have to have public comment. We do 3-minute limit, and they can testify about anything relevant. You are able to say if it's repetitive or irrelevant, to speak to that person, but usually let them speak in less 3 minutes, and then that's testimony. If they're neighbors, if they're community members, that's relevant in some manner. It could be relevant. Then the applicant and the city staff has the opportunity to give closing statements. Then you can ask questions as a commission throughout the hearing, but then you have that time where Chair Olson usually says, does anyone have any questions? You can ask questions at that point to anyone who's testified. The applicant, usually the applicant or the staff, you're not usually questioning public comment. I wouldn't recommend that. Then the chair closes the public hearing. So that's the part where the public is participating. Now it's the public has to view how you guys deliberate, but now you don't have to take any more public comment. It's more about what you guys are thinking, and you're thinking out loud. We like to, we say like start, or Cindy says, everyone what are you thinking about? So everyone could hear what everyone's thinking, and we'll go back, the next slides will say what you should be thinking about, objectivity, but it's appropriate for you to think out loud in this setting because the public, again, gets to see what you're thinking about. You're all talking, you might have questions. So you could ask, the planner, the attorney, the applicant, you could say, oh, well, you said this, can you clarify this? So it's all out in the open. It's almost like everyone's seeing your gears turn and how you're making your decision. That's deliberation. And then the call for the motion, which we're going to explain more. We do in the outline as well. So taking action. This seems simple, and again, you guys are a very experienced board, but sometimes things come up where you just need a refresher, or it's just a bizarre situation, and it's like it's good to remember how everything should happen. So when you taking action means the motion. So I move to recommend approval to City Council for, let's say, a rezone based upon. So in the last few meetings, I know that Michael, the planner, has said, like, made clear in his staff report, or even verbally during the hearing, talk about your findings. And that is important because the findings don't necessarily need to be all said in the motion, but it should be referred to during your deliberations that you then refer to in your motion. So you want to make sure you're drawing your conclusions on evidence in the record. So, because why else would we have a public hearing, right? It's because you have to make your decision. Remember, you come with a clear mind. You're not biased. You hadn't had any ex parte communication. You are listening to all the evidence, and that could be all the letters submitted, the staff report, the architects, the consultants, everything that's in the packet, and the testimony. And then you're applying that to objective code criteria, factors, or requirements. So that's the important part where we usually say, and you guys are good at like listening. If the lawyer is asking or the planner is kind of saying something, or Andy, we're not just talking to hear ourselves hear our voices. It's, we might say, well, why are you making that decision? We could see that you are making it objectively, but it's good to say it for the record so everyone knows. So you're not making a decision based on your personal opinion, based on your neighbor's personal opinion. If 100 people come to a public hearing and they are against something, and the only reason that they're against something is because of of a bias or a prejudice, and otherwise the code applies and all the factors apply, it would be not correct for you to say, well, all these people spoke against it, so I'm going to vote against it. That would not be appropriate. So a lot of what you do does take courage. Think about when we spoke legislative versus quasi-judicial. So legislative is democracy, right? Quasi-judicial, it's not democracy. If 100 people are against something, that doesn't mean that person's property rights, according to a code that has been legislatively adopted, should apply. If I go back to Law and Order, there could be a murder trial, and somebody who 100 people think is guilty because of the media has said, they're guilty. That doesn't mean that person should go get a life sentence. The judge looks at the evidence, right? So that's very important, because I have heard in certain hearings, not in the city, but sometimes it's like, well, we just heard from 30 people and they're all against it. So that's right. That's very important, why I'm kind of zoning in on it. Vote on the application or request before you. That's important. It seems simple, but a lot of times we get caught up with, I guess it goes back to what we're talking about, separating requests. So if someone has a request before you and you kind of talk about something that's next, or just another section of the code that's not appropriate, you got to stay focused. And again, you have a good chair. She just keeps you focused, but and we have good staff. So, but that's what that means. A failed motion, I've had this a lot recently, not here, but in a few other cities. Sometimes it's like, like let's say you have 5 people, 5 of you present, and 3 vote against something and 2 vote for. That means no recommendation to City Council, but it also means nothing's happened. So the applicant has a right for action to be taken. So if a motion fails, then the one person, so let's say it fails 2 to 3, one of those 3 members should then make the opposite motion or a different motion. So then it might be like, let's say 2 people say they recommend to deny, 3 people voted against that. One of those 3 should say, if they feel that everything's warranted, I move to recommend approval, and then see what happens. So that's very important. Recently, another city of mine, we went to City Council and there was absolutely no recommendation. The City Council was kind of like, well, we don't know what to do. And that's not fair to anybody. That's not fair to the applicant. They have a right for as much as you can to make a recommendation. That's their right. So conditions of approval. So, oops. So let's just to go back, taking of action. There's three ways to take, well, usually 3 ways to take action. I'm sorry, I'm like trying to move my face out of the way so I can, okay. Either you're recommending approval, denial, or approval with conditions, conditional approval. So a lot of times your staff report or you guys will add, well, I want to recommend this, but I want to add these conditions. And we help you out with that. Or the staff report says like these 3 conditions. So we're just going to go over what's acceptable and what's not acceptable. So these are just examples. So an acceptable condition is something that relates to that code or that code criteria or some other code criteria. So, you know, preservation of trees and vegetation, if that's in that part of the code, or the last one, conditions offered by the applicant. We can't force the applicant sometimes if it's not related to impose a condition, but a lot of times, maybe you've noticed if an applicant comes up, I'll say, a condition comes up and I'll say, you might think I'm not answering your question, but if there's a reason, I say, well, does Mr. Smith agree to that, imposing that? And you might say, well, you're not answering my question. Can we do it? It's more, can they voluntarily impose it? If it's not technically somehow related to the code. And if obviously if it's totally out there, I'm just gonna say no, but sometimes there's things that the applicant can voluntarily allow. And then unacceptable conditions would be a density restriction where the code doesn't allow you to do that. You just don't like density and you're like, well, no, I'm gonna, you can't do that. So we'll speak up. Matters outside the scope of what they're asking. Conditions which have no code basis. So I don't know if there's a restaurant, I don't know, going for something and you want them to, I don't know, impose happy hour or something. I don't know. That's totally out of that. Something that's totally nothing to do with the code that you're imposing. That's not okay. But you guys are pretty good about thinking, well, can I impose this condition? Can I not? And we help you with that. And that's because I love working here because you guys really want to do the right thing and make sure it's fair. So usually we just go through that process. But now you know what, like kind of maybe what we're thinking. So then I just thought, I'm almost to the end. I just thought this would be a good example. I don't want to get into the weeds because every application is different. There's so many different conditions that can be imposed, but just to kind of talk through generally conditions. So this is a section, part of our section for conditional use. Oh my gosh, sorry. So conditional use is the best thing to talk about for conditions, but it's where a use is not automatically permitted or denied in your chart. It's for conditions. So, and there's different criteria here. So one is, let's look at 3 at the bottom. The proposed use will not result in impacts to the adjacent properties, which are different in nature, type, extent. So if you have perhaps a daycare that is conditional use in a residential neighborhood, and they're going to use their backyard for the play area, and there's no other type use on that block, but otherwise it's not going to impose any negative impacts. Appropriate condition might be certain screening or higher bushes in the just around the property. And that's to be fair to the adjacent property owners, and it's also to be fair to that property owner themselves, because if they could have that use with just this condition, that's fair to them as well. So we try to work through, as long as it's objective. It's very important, objectivity. Annexation is, a lot of times these conditions will be worked out with staff. There's a lot of discretion and flexibility. But for example, certain public facilities, we want to make sure that they're they usually be an annexation agreement, but you want to make sure that not you, but the staff will make sure that agreement will make sure that they have enough, they're hooked up to enough drainage, water. Otherwise, they might have to pay for the impacts of their development. So that would be the appropriate conditions. Final development plan is you know, you need to, when you go through a final development plan, it needs to be in compliance with all the development requirements in the code. So the bottom with the blue these are just different examples. You have a lot in your code, but you know, recently we had a sustainable green building issue that came up. I think it was either last meeting or the meeting before. Certain architectural facade, roofing. Staff will help you with all this, but there's more latitude with final development plan. I think it's a good example because you might have a condition, you know, certain conditions, or it might be said a certain way that, you know, maybe the applicant does not include one thing. You could include it if it's objective. That's the end. I hope I wasn't talking too fast. I've heard that I talk a little fast, but does anyone have any questions? Again, this is the fundamental, the football, but I thought it was better to give that foundation, that refresher. A lot of you probably knew a lot of this, but it's good to remind yourself, especially for your residents. You know, you have a lot of growth in Idaho Springs, a lot of proposed applications, and it's important. I know it's important to you all. You really care about your community, and it's important. Some of these things are not, they're not intuitive, what we do. So it doesn't make sense to maybe it doesn't make sense to certain residents, and you have a good explanation. Not everyone's always gonna understand, but at least you're not just saying because, you know, because I know you really care about your community, and you also want to do the right thing, which is, again, fairness to everybody. And if there's just one thing or two things, it's just think openness and also objectivity. So look at the criteria in the code, look at the factors, make your decision based on that. That's your job. And if you do so, we'll double your pay. I do not know if I have questions.
Nina, I have a question.
Yeah.
So
I'll stop the share now.
So when we make a motion, like to deny something, then we should turn around and make another motion then to recommend to council that the motion was denied by the planning commission?
Okay, I thank you for asking that because I probably wasn't clear. So let's say you make a recommendation to approve whatever application is in front of you. You make the motion. And then you have 2 people who vote with you and 4 people who vote against it. The motion has failed, but that means that there's been no recommendation to council.
Right, so another motion should be made for the recommendation to council.
Right, the other way.
That's my question. Okay.
And there are some circumstances where maybe you'll never get to something, but usually you can get there. So yeah, and with you as planning commission, it's even harder with the motions, because motions, understandably, sometimes like double negatives and everything, because sometimes you're saying I approve, and maybe sometimes I jump in, well, you're recommending approval in this case. So it's like, you know, and then it's like, so it is a lot sometimes to figure out, but that's, you know, that's why you talk it through and everything. Does that make sense to answer your question? I probably wasn't clear with the way I explained it.
No, that makes sense. I just was making sure I understood it.
Yeah.
Nina, could you mention something regarding when would a continuation be
But it might
appropriate on
seem
an application?
redundant. For example.
Yes, that's a good question, Mike, because we had, I'm not sure if it was this board or variance board, we had that recently. It's appropriate. So again, we spoke about someone's property rights and their right for their application to be decided upon. In certain circumstances, it's okay to continue if more information is truly needed. There isn't an incomplete packet either by staff or the applicant. Or maybe you want staff to look at something that is relevant. And we'll tell you whether or not, but it's not appropriate when there's 100 people in the room. It's a difficult decision. You're just in a not good mood. It's a full moon, you haven't eaten. You just don't want to make a decision right now. It's hard. I mean, again, you don't get paid much. That's not appropriate to continue just because and I don't say that, I don't say that quickly, or just, it is a hard job that you guys have, but you can't just continue just for no reason. Does that answer your question?
Yeah.
I know you're trying to have me share to the commission, but did I share enough of that?
Yes. And one other question. Sometimes I've seen occur elsewhere in a hearing is that after the hearing is closed and it goes to board discussion and something new is brought up that was not actually discussed or presented regarding during the actual public testimony or hearing portion. And I've seen the applicant get somewhat agitated about, well, I didn't get a chance to address that comment. What if something like that occurs, what's the appropriate response?
Yeah, it depends. I mean, do you mean if a planning commission member has an opinion that the applicant just wants to counter?
Well, if something new is brought up, in other words, if you were to look for a finding or evidence in the hearing or in the application or in the staff report, there's nothing in any of those about a new topic that comes up during the discussion by the planning commission. And again, what I've seen elsewhere occur is that applicants will say, I didn't get a chance to comment about that.
Okay. Yeah, it depends. And I know I will explain because I don't hate people hate when lawyers say that. Usually when I see contentious hearings where an applicant is jumping in saying that, it isn't new. It's just they want to say something else to argue. If it's truly something new that's brought up, like maybe they asked the planner and the planner, or let's not say the planner because you guys do staff reports, but let's say they ask fire, the fire chief happens to be there, I don't know, and they ask a question. And then that wasn't included in the staff report, that something concrete that the applicant says, wait, I want to talk about that. I do have sprinklers in my housing. And then it's appropriate. So it's kind of like, that's why we're here at the hearings to kind of say when it is and when it's not. So if it truly is something new, then we should give them the right. I always try to err on the side of that, but I've just seen that issue come up more than likely. It's the other side where they just want to keep talking, and I don't know. It's just that's when that happens. It's kind of no. Okay, now it's time for the intendants to deliberate. You have the right to see, but not to just keep throwing in your little arguments. So it depends. But if it truly is new evidence, then yeah, I agree that it should they should go back to the applicant, but not back to public comment. So obviously, but yeah.
So I also wanted to just point out at a couple of the recent hearings, and I think Planning Commission has done a really good job. And I know because we're on Zoom, it may seem like redundant, but like one of the last applications that came up, Mike spent some time reading the findings into the record. And it's sometimes hard to listen to that, but again, as staff, we want to make sure that those findings are on the record, particularly in this Zoom, this sort of new thing. So I just wanted to point that out because the projects that are going to be coming in front of you are going to become more complex. And I think it's, and we've got some people that you may see that sort of do a lot of pushback. So this is one reason for the training, is just because we've got some pretty mouthy potential applicants.
So yeah, it's very important to have findings, but it doesn't necessarily mean, I agree. I mean, I agree with what you're saying. I just want to clarify. It doesn't mean that, you guys have to reread your whole staff report because that's in the record. Right. But I know the times that you guys have been pointing it out is because findings haven't even discussed at all. So, it's kind of like I said, when they're deliberating, they should talk about the findings, and then maybe they can say, based on the findings on this page of the staff report. There's no need to read a whole just for the purpose of reading it because that's in the record. But but definitely, it's good that we're keying in on the point of having findings, which I said you need to have findings are a reason why. Be clear, because a lot of times if something is simple, we think it's simple, we just let's move to approve, and we don't even talk about it. So to your point, yeah.
And again, Nina, just to point out, the staff report does not need to be read into the record verbatim, but I think that basically saying, okay, per our staff report, here are the following findings. and we don't have to, just in the interest of time, read them verbatim. But again, to allow the applicants, and we've more so not with planning commission, but with the variance board, we have had to be very careful in terms of ensuring that the applicant understands the basis of the decision.
But just to clarify, the commission is, I don't disagree, but I just want to clarify that the commission is the one making the decision. So a lot of times, obviously, they base that a lot on your expertise of your staff reports, but it's more important that the commission either refers to the findings or talks about findings rather than the staff member. But I know we're saying something. I just want to, I've seen exactly what you're seeing to make sure that everyone is on the same page.
Yeah.
Are there any other questions? I did get a message that some parts I spoke too quickly. It's hard on the computer when you're not engaging. So if there's any parts that you felt I rushed through or that I should flush out, I could do that.
I have a question on going back to the findings and supporting documents. When we notice that, okay, that isn't what our interpretation is, that isn't what the comp plan said, but yet it comes from the planner saying in their report that's part of the record, that's kind of a tough one because you want to correct it.
Right.
How do you go about doing that?
You should bring it up because if we look at a public hearing, it's not always contentious, but there's multiple sides there. The staff, obviously, we know that they have good expertise, but we don't just rubber stamp. So we rubber stamp their. So, they're presenting their side. Like, let's think about the judge again with the prosecutor and the criminal attorney. The judge probably has more in common with the prosecutor and usually sides with them, but they could go the other way too. So they have to take everything into consideration. So the staff findings or the report is kind of one of many sides that you're considering. Again, of course, it's usually, it's obviously gone in more depth than anyone else, but you also have to consider the applicant. And then also if you have questions at the deliberation point is when you would ask questions of any staff member. So I know in that situation, I know the situation you're talking about, I think you asked either Jonathan or Andy or me, like, well, what does the comp plan actually say? And that way we answer so it's on the record. So you're able to ask, that's why all these staff members are here, all the expertise. And it doesn't have to be staff member, it could be the environmental consultant for the applicant. You could say, well, or the traffic consultant. You could say, well, what about this, I want to see clarification, and you guys have done this, of this, I'm looking at a piece of paper, it doesn't matter, but what is, can you further explain, or this traffic study, or I don't really understand how this part makes sense. And then that way that's in the record as well.
But we should be getting that false information though also. Right?
That's beyond my, I understand.
So let me give an example because I think it's come up previously. What's interesting about the Idaho Springs Municipal Code and the comp plan is this is a community that really understands shade and shadow. So let's say that the planners did not include shade and shadow considerations in something that you're reviewing. So Nina, the question then to you is that Cindy or Kate or somebody could then say, Mike or Barb, what about shade and shadow considerations? It's in the comp plan, it's in the code. There's actually a diagram in the code that sort of shows the shading or whatever. Does Cindy or whoever then ask for our opinion, or does she simply state that per the code or comp plan, we are very concerned about shade and shadow? It's reflected in our comp plan, it's reflected in our code. This is one of the few codes that has a diagram of what the shading is like at different times of the day. So how would the commission handle that if we as staff had
Lost
not
me.
specifically addressed that?
So yeah, they could ask staff questions further about that. Or they could read it them. I think back to Cindy's point, she could read it herself if it's objective and it's clear in the comp plan. If it requires technical expertise, then it's appropriate to ask the staff member, whether it be planners or again the traffic consultants. I want to bring up something since you brought this up. It's not appropriate if one of the planning commissioners is on their own. And I see this happen all the time everywhere. If one of you is a traffic consultant or one of you is an engineer, it's not appropriate for you to say, well, I'm an engineer and you haven't done the study and I know that this and this. That is not appropriate because when you come to the planning commission, you're not supposed to bring your technical expertise. You're coming as a community member applying the code. And I know that's not what Barb asked, but it just made me think of something else that I've seen come up, that it's not appropriate because you as the engineer, you might be an engineer, and I'm not dismissing your experience, but you didn't study everything related to get to that report. And that's your general interest or background is why you were chosen for planning commission member, but most importantly, it was a fair, objective member of the community who cares. So does that answer your question, Cindy?
Yeah, it kind of does. Yeah.
I know what happened. What issue, Tanya, you're talking about with the comp plan, and that's more. We have to make sure that we talk with. Maybe we should look through our. I mean, I know you guys all do this, but look through the packets, make sure everything. If I would say as staff, all of us, if the commission is repeating themselves multiple times about something that they see, we should kind of take that and look and take that into consideration. Like if someone's saying, well, I don't see that what you're saying in the comp plan, we shouldn't keep repeating it. We should ourselves as staff look into that and think it through.
But again, the comp plan, unless the city decides to do differently, is only a guide.
Yes, I know.
That's true, but it's a guide that we adopted, so we don't want the planners overstepping what we've decided, and you think that, well, this is better. So it is a guide that we try to follow, and maybe it's changing the guide. I don't think it's right for the planners just to assume that they're going to go up above and beyond it, because that's where it's not going to fly. I mean,
right.
I agree.
Totally,
Thank you.
Cindy, I totally agree. And I think that what's fascinating about the Idaho Springs municipal code is your municipal code ends up delving into some other areas that are not typical. I think it's great that the code has delved into that, but the code will trump the comp plan. So for example, with respect to shadow shading or whatever, I love the fact that I can go to the code and I can see this diagram that's in the code, might be in the comp plan also, but the fact that it's in the code provides more power than simply being in the comp plan. Because we write a lot of comp plans, we have over many years, and you get into this issue where people then start parsing what the comp plan says, is it a may, is it a shall, or whatever. There are some.
I don't know why we keep talking about this part.
Okay.
I mean, why do we keep going back to the shade thing?
Well, it was just an example because
Okay.
and there's going to be a project that is going to be in front of you, which is Gold Digger Field, where that issue will also come up again.
Okay.
So
that's where the shade, okay. Okay, Nina, I think that was great. Does anybody else have more questions?
If you do, make sure you let me know. You can always email me because it's probably something that's on many minds, and then maybe I'll send something out to everybody. I will send. Should I send it to Diane, that PowerPoint, Andy, to send to the commission? That we have something else. It's mostly based on the outline, but it's always good to have tools and everything. So
Well, it's good to have it as a guide too for us to have in front of us when we're doing some of this. Yeah.
yeah. And I enjoy working with all of you. It's always, you have a lot of exciting, challenging things coming up, and you're always looking at it with a good lens. You're always trying to do the right thing. And that's why we're even having this refresher. You all have good personalities. You really care. I just really love working with this commission. So thank you for giving me the opportunity to.
And we with you, Nina. Thank you so much.
Oh, thanks, Kate. I appreciate that.
Okay, who was doing the next part? Andy, were you with the
No, I think I'm going to do it.
splitting up the two? Okay, go ahead.
Okay. Jonathan, were you going to share the screen? So this is actually something that Mike prepared, and then there's a lot of back and forth with Carmen and the planners and Nina. So this is about both pre-application work sessions and community meetings. Next slide.
I think it was that screen that showed up.
So the potential goals of a pre-application work session or work sessions is for the applicant to receive early feedback from the commission's perspective to facilitate and encourage public involvement, from the community's perspective to increase awareness and involvement. We did want to point out, as I'm sure you all know, that the code already requires a pre-application meeting with staff for most application types. From the commission's perspective, are there other goals that you would like to achieve with a pre-application conference or meeting?
So just a quick question. I assume this is going to lead into rezoning rules and stuff like that. And just wondered what is considered a spot zoning? In other words, somebody will apply for a zoning change for a particular project and they have to change it. Now, what's the criteria on that?
So let me, and then Nina might want to chime in because I know she works for Fort Morgan, and we've worked in Fort Morgan where spot zoning was quite prevalent. So when you look at spot zoning and what constitutes spot zoning, if I decided that I wanted to come in front of the city and I had two parcels, let's say in an R1 zone district, and I came to you and said, I want to take only these two parcels that I own, and I want to zone them C1, that would probably constitute spot zoning. So when you're looking at how something should be zoned, you're looking at land area, and you're also looking at the adjacent zone districts. So you're not just picking a parcel here and there and requesting rezoning to something that, one, is not in keeping with your comprehensive plan, and doesn't sort of fit the character of the community.
And just to go back to what I was saying about looking at things objectively, rather than, it's kind of like the spot zoning is the negative, like kind of the negative. In the affirmative, we're really, instead of just saying, is it spot zoning or is it not spot zoning, we want to go back to our code, section 21-108 rezoning, and that on subsection F says consideration, you consider the following factors, and there's a list of about 8 factors. So rather than kind of saying that it's not spot zoning, it's more, does it fall under these criteria, which ultimately will get us to the same part, place that we want to get to. But we want to focus on our code requirements, our code factors that are listed in that section.
And also, essentially, public opinion is kind of a moot point if going by the code and so on and so forth, it's allowed. So even though you have a public meeting with a whole bunch of people, if the code allows it and it fits in the comp plan, it kind of goes through.
Yeah.
Well, a lot of times I didn't mean that public comment is irrelevant, which I kind of went that far. I just meant if every single person who's speaking is only against a project for their own personal reasons and not because of the code. But a lot of our code sections, for example, conditional use is it compatible with the neighborhood? So it's appropriate for the people from that neighborhood to say that it's not or it is. And it's appropriate for, the members of the community who have lived here for many years or however long they've lived to look at the code and say, well, these 3 sections of the code, I know that it doesn't apply because I know that there's no way that this parking variance is appropriate because I live on this road and there's never any free parking spaces. So, those are more objective than just, I hate poor people, we shouldn't have affordable housing. And that's obviously, I'm being glib, I'm being generalistic, but so public comment does matter. It's just that if their comment is only about their personal feeling, then it's appropriate. It's not appropriate to consider solely for your decision. And we do want to make sure everyone feels heard. So it's not just that goes a long way as well.
You guys, let's go through the PowerPoint and then ask questions because it gets too confusing when we go back and forth. So let's we've all read through the PowerPoint. So can we kind of just go through it kind of quickly?
Yep.
And then all of us ask questions.
Okay.
Okay.
Thanks, Cindy. Okay.
Just so we can keep, because we get too scattered. Yeah.
Okay. So any other goals that you see for a pre-application work session? If not, okay, let's go to the next slide. So the potential pitfalls of a pre-application work session or work sessions, and this is something that Carmen, Nina, and I all worked through, is commissioner comments must avoid expressions of pre-decision or prejudgment. So that's the same thing that when we have a pre-application meeting, the staff with an applicant, we make it very clear that anything we say is prior to the application and they cannot hold us to whatever we say. So again, expressions of prejudgment disqualify a commissioner from participating at the formal hearing, and it exposes the final decision to legal challenge. Second point, may confuse public if purpose is unclear. I have to come back and testify again if I don't like this. May mislead applicant if the feedback is overwhelmingly positive or negative. Could deter potentially beneficial projects when controversial. May create expectation of eventual city approval when public opinion is positive. And due to these risks, the city attorney's office recommends against pre-application work sessions with the planning commission or city council. So I do want to add to this, and this came from Carmen, and I truly appreciate this. There are certain types of applications where the planning commission is able, because it's in the code, to discuss an application. And the best example is if you had a major subdivision that came before you, there is a provision in the code that allows the applicant to provide a conceptual plan of where they are going with the subdivision of their property. So that provides you with information about infrastructure, where the streets are going, sort of what things are going to look like. But the question that Carmen wanted me to ask is, should work sessions ever be required given the relative risks and benefits? Cindy, do you want me to continue and then we come back and talk about
Yeah,
that?
I think kind of go through this, kind of summarize it, because there's 15 pages. So I don't think we need to read every line by line.
Okay,
Um,
next.
I think hopefully everybody read it.
Well, the problem was what went into your packets is a little bit different than what was here because Carmen had some changes. So I just want to put that out.
Well, I
there.
think Diane sent out the corrections.
Oh, okay.
Yeah.
So again, I think the two things that I want to talk about, so these are the type of applications, you all know these. I do want to point out, again, a little bit of a unique piece of your code is final development plans under the municipal code. That's the only type of application that requires a community meeting. And for additions that are less than 50%, the review is by staff only. So I do want to point out, I've been discussing this with Andy, 1800 Colorado Boulevard is going to be expanding, but it is less than 50%. So in discussing this with Andy, we just got the application. We will inform you of what that application is about, but you will not be deciding on that application. So next slide. So just to go through the process, there is a required pre-application meeting with staff that is in your code. What we have done recently since we've come on board and to the benefit of the applicant is sometimes those pre-application meetings occur with Andy, the planner, John Bordoni, Tracy Lawless, and maybe the attorney. So again, there's a required community meeting with public notice, and right now it only applies to an FDP. You could, after that community meeting, and this is a discussion point, have a planning commission work session with public notice, but it has to be prior to formal application. Next slide. So one of the things that we have been concentrating on is just sort of buffing up, sort of making sure submittals are complete. So people provide a pre-application form, they pay their fees, it's a project narrative, it talks about existing conditions, it talks about the proposed development. One of the things that is really key, and we've started instituting this, is the city needs verification of the applicant as owner or representative. So if I'm a planner that's working for Project Z, but I'm not the owner, I need to submit to the city authorization that I'm able to represent this applicant. So I think the question there is, should a pre-application fee and deposit be required? Next slide. So in terms of any sort of submittal, again, this is if you wanted to have a pre-application work session. We think at minimum, you need a surrounding area description, a site description, project description, some evidence of compliance with criteria for approval, and just basic project statistics, because we have found that some of that has been pretty loosey-goosey. But again, Idaho Springs is moving from a community where you know everybody that's doing the development to new people that are coming into the community. So the question there is, what information would you as planning commissioners like to see? Next slide. So in terms of submittal exhibits, a vicinity map, is really important to sort of show the surrounding properties and buildings. It's also important to understand the existing site conditions. We need a site plan, and we really need, again, because you are a community of many historic resources, both cultural as well as building. So it's important to see sort of the size of buildings along the street. If this project goes through, how does it relate to the other projects? Again, so the question to all of you is what do you really need to see to make an informed decision? Next slide. So one of the great things about Idaho Springs and Clear Creek County is Clear Creek County has what's called ClearMap. And it can be used on the internet to make an inexpensive vicinity map. So you see the site here. So you can see on ClearMap property lines, streets and street names, buildings and parking areas, addresses, etc. But again, I want you all to understand that at this point in time for a community meeting, the public notice is only to owners within 300 feet. So the question is, do you want to extend sort of who gets involved in a community meeting? Next slide. So I think Mike and I think, particularly sort of given the rock and roll topography of Idaho Springs, that and Argo did this in their submittal. Do you guys want to see sort of the size or mass of a project? Should that be a 3D? And it could be any of these, a 3D model, a 3D drawing, a streetscape drawing, etc. But there's something, and again, technology is really wonderful because all of these images are easy to develop these days. Next slide. So the work session parameters, and again, this, thank you, Carmen and Nina, for this. So the applicant would present the concept plan, the staff would provide input, the public would provide input, question and answers, again, general feedback, recognizing that the feedback that you provide is not binding. There's no vote by the commission, and there's no expression of prejudgment. Next slide. I think that's it. So that's sort of the overview of the pre-application process and the community meeting. So the community meeting is in your code right now. The question to the Planning Commission is there was some want to have more pre-application meetings. We have heard loud and clear from the attorneys that they're not in favor of that. So we just need some discussion on this.
Okay, where do we go from there? I still think there's needs to be work sessions before when they're bigger developments, especially after the last incident, because I don't think it was represented on the side of what the commission envisions for the city through the comp plan. And so I think when there is those bigger projects, it does have to have some type of pre-meeting.
Can I just clarify, or maybe it'll help. There's difference between, the pre-application staff meeting, and the staff usually is representing the city's needs and kind of has a feeling, especially when the planners work there for a while, they have a feeling of, what the community wants or what's going on, and that's a frank discussion. So those type of concerns could be addressed there. Then there's the community meeting, And then there's a difference. So the difference between the pre-application staff meeting, the community meeting, and a pre-application work session with the planning commission. And because of how much development the applications there have been recently, and the reasons why I went back with the quasi-judicial and everything, there's just worries to have that work session, and some of the concerns I think you validly have, Cindy, could be addressed in other forums.
Well, and that might be it. I don't know what that is, but I mean, it doesn't mean the applicant is there at the work session. It means that, okay, the planners have a sense of here's what's coming before you. Let's have a work session, discuss on what the city's stand on it might be. Can you do that? Not where you're prejudging it or pre-anything, but where you can have some input to the planners, say, well, no, we don't like to go above 35 feet. Which reminds me, how tall is that thing down there?
So let me ask you this question.
Is that supposed to be at 35 feet? The clinic?
We were not able to review the clinic.
Well, we still have a city code that says 35 feet.
Right, I understand.
That was the county was the applicant though, so they have.
I know, but that's not what we agreed on. But anyway, okay, sorry, I didn't mean to go off on that.
So let me ask you this, Nina, because I understand fully where Cindy is coming from. So, and I'm going to take a different project that has not come before the planning commission yet, but will. So we all know that Gold Digger Field is going to be redeveloped. That is a large development. It is a very complicated development. There are certain things that the city wants out of that development. They have not made an application yet. Could the planners, without the applicant, have a work session with the planning commission to sort of discuss all of the moving parts of this application that has yet to be submitted?
I don't like that. In most of our cities, it's not the planner and the administrator knows what the city wants. So you have those private staff conversations.
Which I would agree with that, but I don't think that's what we're seeing. I agree with that. They should, but I there's a difference in when we had Andy on board than having these guys on board. And it's not picking on you guys or anything. I guess maybe it's the mindset that it's a temporary thing still, that wait, where are we going? Are they representing what's the best interest for the city? There's that sense of, because it's not that knowing that you're going to be there and stay there, sense of, wait a minute, are they doing what's best for what the city's doing? And I know they go through Andy, and Andy should be passing that on to them, but Andy's got his plate full with doing stuff too. So I think there's that sense of that it's not being represented.
Well, and if I could add, if I could also add just before I forget, when Barb asked her original question for a work session, remember we've had a lot of work sessions for housing, for example, or we could have general topics, and we got a sense of how planning commission feels. So you don't necessarily need to have a work session on a very specific thing, and you definitely should do it without the applicant, all the details, but we could have a work session. We've had work sessions on affordable housing, and we've spoken about what kind of things you like to see. So once you get that, the planning commission is sharing what the community wants to see. And when it gets to the specifics, because I'm involved with this in a lot of other cities, we have those meetings, those staff meetings, and we say, listen, it's very important that the planning commission, we know that they need to, or Idaho Springs is very important about parking. You gotta make sure you have parking. You gotta do this. All that could be accomplished without
this specific project. I get what you're saying. And yeah, I can see where that probably isn't the best way to do it. It's not fair to the applicant because it's being pre-positioned and predetermined before they're actually submitting their application.
And the concern that you are validly concerned about, it's again, it's usually the staff has a feeling of how you guys will go, and not specifically again prejudgment, but generally, you know, maybe I have a community that's really important about trees. Like trees cannot be removed in any condition. It's like
so it could be a work session on density. Let's use that as an example, but not on the project for the football field. So maybe we'd have a work session on density if that was becoming the issue that the planners are seeing, that wait a minute, maybe this project is getting to be way more dense than the city's going to want. Then you would have a work session on the density, but I can see where it's not specific to the project.
And you have allowed that, you know, Carmen has allowed or authorized, I guess, or recommended that you can have a work session in certain circumstances. But that was just, you know, we had to make sure it was we had to make sure, again, all those things I spoke about were, you know, the prejudgment, the ex parte, we had to be very careful. But the concerns that I'm hearing that you have are general concerns that the staff and at the planning level should have those conversations. It's usually those pre-application staff meetings. And one thing I didn't mention that was in my outline that wasn't in the slide is a planning commission can talk to the staff before a hearing, or the planning commissioner can direct your residents, your constituents, your neighbors to go speak to staff. So that kind of is, that's a way for the residents to get around the quasi-judicial, not get around, but to be fair that, you know, your neighbor asks you every day about something, have them ask the planner or Andy about it. But you seem to have, again, validly, this is your community. You guys have specific concerns. If you know, you've been to those meetings, you've heard those concerns, then when we sit down and meet with the staff, I mean, I don't do it in this city, but I do it with other cities because Carmen is the main attorney here, but I just had a meeting 2 hours ago. We were very frank. We're like, well, this is very important to the community, you know, but this might not fly. So it's like your general concerns are still being listened to, but they usually have on the staff level. So.
Okay, so another question then, can Andy have a meeting with a work session with the commissioners on potential projects that are coming up and talk about, okay, here's what's coming up, and get some sense of ideas on it? Then when he's communicating with the planners, then they're getting the information.
I think you guys, you don't call it a work session, but I think you used to do that where Alan would say, like, these are coming down the pike, and, you know, you guys would talk to him about it. But I would say, just myself, having been to almost all your planning commission meetings for the past few years, I don't need to have a specific conversation with you guys on a specific property to know what's important to you guys.
Yeah, and I agree with that also. Let me throw out a couple of things that I think sort of where we might want to go. One, I think that the community meeting in terms of notification should be more than 300 feet, because this is a really small community, and you take any project that's coming along, I think the people that need to be notified needs to be greater.
But what is that going to do? If you guys had a public meeting and you extended it to 500 feet, you take that feedback and then you take it back to the applicant and tell them that, okay, this is the negative, this is the positive.
Yeah.
We as commissioners don't know that. Well, that's what happened with the last project, but I think there was more negative in that meeting than there was positive, but that's not the way it came about then.
And Cindy, that may have just been, I mean, I know Mike sat down with Alan on that particular project before he left.
Right. And I know it was that timing of everything with Alan, but why do you think the 500 feet is going to?
It might be 1,000 feet. It might be put a notice in the paper, because So my other suggestion, one, so you increase sort of who gets notified on the community meeting. I also think there are some policy issues. So what we have been providing to you guys monthly is an update of what's coming down the pike. Okay. Andy loves this. I love it because it sort of gives you guys an idea of what's going on.
It is, it's good, actually.
But
Yeah.
I think that we may now be at a point where instead of having work sessions, and I'm trying to follow you here, Cindy, on particular applications, I think the time is right to have a work session on sort of the number of housing units that are coming down the pike. So, and I can say this and let me know if I can't. So we have 2,800 minor, 69 units. We have an FDP for 1,800 Colorado Boulevard, 10 units. You're not going to see that. We have the football field, of which I've been providing the mayor and Andy with some information on. You're looking at 100 to 120 new units on that football field. So that, in my mind, from a policy perspective and a comp plan perspective, may just be a general discussion of what's coming down the road and does the comp plan, you know, I have been in a lot of these small communities when they're going through this type of growth. I first worked in Idaho Springs in '83. I worked in Idaho Springs in '99, 2000. So I have a sense of how much you have grown and how much you have changed over 40 years. My concern with Idaho Springs right now professionally is with the Argo development and the need for more workforce housing, whatever. You've got developers already lined up. Idaho Springs is going to be very different because of Argo than it is today. Is that something you want to discuss at a policy level, Planning Commission?
Okay.
So do you mean, just to clarify, do you mean housing in general or in that specific location?
No, I'm talking about the fact, I saw this in Frisco, I saw it in Linwood Springs, I saw it in Salida. I mean, I can name all the mountain communities.
You don't, you just have to finish the question.
Yeah. So I think that what I'm concerned about is that the type of projects that Idaho Springs has seen previously. Some of you know Tim Caters used to work for my firm, so he was a planner way back when. Then you had Alan. I'm just concerned that the type of development and the complexity of the development that is coming down the pike is very different than what this city has seen before. And I think professionally that it's really important to help the Planning Commission understand, and more importantly, provide really good information on what do you think about this?
But just, can you just maybe in like 1 or 2 sentences say like what the work session would be about? Would it be about specific development? Would it be about what the buildings look like? Just like, what do you mean? Just so I can if I need to.
I think that a work session about the change that is likely to happen. So if we outline to the Planning Commission, we've got these things that are sort of haven't applied, but these are the things that are coming forward. Again, pre-application, not one application, but this is what we're looking at. Can you provide us with some local values, experience, etc., about how you feel about all of this? Because then you also have Soda Creek. I mean, that's still hanging out there.
What do you mean? How do you feel about it? Do you mean just having more development generally? Like, what would we specifically?
It's back to the density issue. It's all of it, Nina. I mean, it's sort of like, you've got a comp plan that I think is really good. It was recently updated, but with Argo and the type of development that you're likely to see in the change in the very fabric of the economy, I think that's worth the discussion with Planning Commission.
Okay, I think we're kind of going off. I think we're getting it that the pre-applicant meetings, work sessions aren't a good idea.
With planning commission, so you could have the
Right.
pre-application
And
staff of the community.
And I do agree that a lot of this should be at the staff level. We should be at the staff level, that we have confidence in what the staff is doing, and they're representing the comp plan and our codes. So I think we get that. I think a lot of this discussion keeps going round and round because of the last applicant we had and the feeling that we were left with, that it wasn't a representation of what the city truly wanted or needed, or was with what was in the comp plan. So I think we're kind of getting off track here. Did you need answers to some of this stuff? I thought we were gonna go over, Andy, didn't you want, if there was gonna be the final development plan at the same time? Wasn't that gonna be a decision to try to have made?
Yes, I mean, one item we wanted to discuss, and we just discussed it, was whether or not we want to consider pre-application work session with Planning Commission on a specific project. And what I'm hearing is it's not recommended by our city attorney, and it sounds like there are a different way we can accomplish that with some of our current procedures. So I think what I'm hearing is that we should not go that direction of having a pre-application work session with PC.
That's what I'm hearing. Does anybody else have any comments? Kate, Uchi, Jordan, any of you guys out there? I mean, that's kind of the sense of what I'm hearing.
I agree.
No, I agree with what you're saying with what
Okay.
Yeah.
Okay, so good. You got the answer to that one, Andy. That's good.
And then
Okay.
the second item, and we can talk about other things here, this is a work session, but the other item we wanted to be sure to touch on was going forward, we as staff recommend that we not do a rezoning and an FTP concurrently, particularly on larger projects. Doesn't mean we never do it. There might be a small project that it might be appropriate, but on larger projects, there's just, they're big decisions, of course. The first big decision is whether to rezone for a particular proposed development. And then the second is the actual details of the plan, the proposed plan for the development. And so we're going forward. We just wanted to make sure that you all were looped in and had a chance to comment on this, or just aware that we as staff do not believe that even if an applicant wants to speed up the process and do them concurrently, that generally staff would not recommend that. So we would say first got to, if you want to do what you want to do here, what you're proposing, you have to get your rezoning first, and if you get the rezoning, then you can come back separate time and do your FDP request.
And it also puts to the findings that we spoke about, like if we're going to look at the objective code factors, it's so different what says for rezoning and plan development. So it just keeps it clean, and that benefits the applicant as well.
Right, and so just so everyone's clear, there is nothing in the code that states that you can do a rezoning and an FDP concurrently.
Right.
It was a practice that when we got on board, apparently people were used to, including the past applicant, because the past planner apparently had let him know that that was okay. I will tell you that whether you're on the development side or on the public side, it makes no sense for somebody to prepare an FDP when they do not have zoning approval for
I think we all
that.
agree.
Yeah. I think we're probably all in agreement too. You guys chime in. And I think that's what was overwhelming about that last meeting we had, is because, wait a minute, you looked at how much this guy had done, the applicant had done, and then to get turned down on the zoning, it just didn't make sense. But there again, I think anything that can be done in-house like that
The staff level, yeah.
is working better for staff is better, yeah.
Yeah.
Okay,
I will-
does everyone else agree on that one?
Yeah, I do. I felt like we were getting coerced and railroaded to push that thing through. That was my
Yeah.
Well,
opinion
and I
right there.
want to go on record that I went
Yeah.
back to the community meeting and I went back to Alan's notes. And Mike had a discussion with Alan before he left. And this particular applicant, who is not my favorite applicant, basically did not hear that R2 was what people were thinking might be more appropriate.
Yeah.
We shouldn't
Yeah.
we shouldn't really be talking about an application that still is technically in process.
Right,
No,
I
right.
agree. I agree.
Mike, did he withdraw his application? Yes or no?
He hasn't.
Okay.
Okay, so Andy, it sounds like you've got direction
Yeah,
on that one.
I've never seen it done. That's on. So we just not do that any other city, any other place.
So we fixed it, Nina? Is that what you're
Yeah, I
saying?
think the staff has the direction not to do that ever
Good.
again.
Okay. Okay, did we answer all the questions that needed answered? And then if anybody's got questions?
Those were the two areas that staff wanted to get direction on in particular. And then if there's anything else the planning commission would like to talk about or give direction on, we could do it now. One other thing I wanted to mention is whether or not there was discussion previously about having another work session to plan for the year upcoming here, where we're already into 2021. So is that a work session that Planning Commission would like to have a special session later this month, or just have it at at the next regular meeting in February, the first Wednesday in February?
And what is it you want to try to get up to speed on? The projects or?
I think it could be what's coming down the pike with projects. It could be discussion about a work plan, things when we're not dealing with development projects. What are some other changes? We've developed, the planners have developed a work list, a list of things that we may want to tackle, changes, things like that. So just be a time to talk about what are the priorities, what are things we want to work on during the year when we're not dealing with specific development proposals.
And Planning Commission has also mentioned there may be several items they'd like to revisit in the comprehensive plan.
Okay. Yeah, I'm open. It can be a special meeting or we can do it at our next meeting, scheduled meeting, unless there's something else that may be on the agenda.
I'm not aware of another item that would be coming to the February meeting. Barb or Mike, are you aware of anything?
No, from a time standpoint for a new application, I don't think it'd be possible to get something to the next meeting for a new application if it were to come in tomorrow. I don't think there's enough time.
Yeah. So
I think it's appropriate to have a work session at the February meeting if Planning Commission's good with that.
Yeah. So yeah, go over these projects and whatever potential things to get done.
So I do have a question. I mean, Andy and I have talked about this. So, there's one application that you will not see. It's 1800 Colorado Boulevard. That's an existing building. It's the Gold Run Center. You are not going to see that because it's an administrative plat amendment and an FDP that is less than 50%. So my question to the Planning Commission is, how should we inform you of that? It's on our activities memo, but do you want to know more?
I think that can be something you can update at the February meeting.
Okay.
I mean, it's an existing building, right?
Right, and they're going to follow the 1981 plan that I have a copy of, and they're going to add 10 housing units.
In that existing structure?
They're going to build an addition to the existing structure.
So
It'll match the west wing that exists today.
Okay. Yeah, I think the update on the February meeting is fine.
okay.
Yeah.
And then
Okay.
at the February meeting, so we could have like a work session on sort of what's coming down the road and just sort of get some sense of policy direction from the planning commission?
Sounds good.
I mean, let me just say this, having talked to Andy and the mayor, the goal is within their 120 days of due diligence. But again, that's a big project. Is something again for the commission and say, do you have certain goals or things you'd like to see out of this project?
Hey, Barb,
Yeah.
we could not hear the last
Nina's looking like,
said.
Is you're spotty. It's your connection.
Yeah, turn off your video. Maybe that'll help. We couldn't hear the last 30 seconds of what you said.
Anything really.
Yeah, I couldn't either.
That's what I was looking at.
It was mine.
That's what you're saying. It was spotty, the connection.
yeah, I keep on getting internet connection unstable. I'm not sure why.
Okay, that's what I'm looking at.
So this is what happens when you update your machine. So my question is, so they have not made an application yet. It's a big project for the city. The city council and members of the city
Barb, I'm
council.
sorry. I just want to make sure, because again, we didn't hear part of what you said.
Yeah, what application?
Gold Digger Field project, correct?
Yeah, so do we want to bring that forward to sort of ask planning commission, what would they like to see out of this project?
Well, I don't think we know anything about the project to know what we want to see. I mean, I haven't seen anything publicly put out there as to what they're doing.
I have been contacted, so I know what they're sort of thinking about.
I would say it should go on this report that we would see at the February meeting. But then you have to be careful, right? That we're not discussing specific projects, right?
It's pre-application. Everybody knows it's coming. So Nina, if I'm correct, can we discuss the use of a piece of property that was public that has now is going to be bought by a developer? Yes or no?
I'm sorry to hear like repeating myself. I'm just not used to this process. I'm used to we as staff know how the city, what's important to the planning commission, that we don't need to get into the specifics, that we know either housing is important or parking, or to get into the specifics is getting to exactly what we spoke about. And I just don't, it's maybe because you guys just want to be sure that you're, on the same page, but I just, again, like just from being at these meetings and knowing the commission and knowing the city, I feel like I would be able to explain to an applicant what the city wants and doesn't want generally without saying, this is this property, what should we see there? It's more the applicant is putting that forward.
Nina, with the comp plan will be the document that says that information, that gives that information?
What's important to you guys, yeah. And then just
knowing.
An art, I don't know how to explain it. It's an art, not a science. Maybe because what we do is an art and not a science. We just have a feeling as to what is important for the city because of the comp plan, because of the totality of all these different hearings and meetings that we've had, that I'm used to, that there's no need to have that pre-application work session with planning commission, that the staff knows what is important, what the city wants, and city council directs that policy as well. I mean, not the planning commission, but and so that's usually for the planner, the city manager, the city attorney. That's the process I'm used to, is that we all work together, knowing what's important to the community.
So it sounds like it goes through staff, the normal process of what is acceptable, what's not going to be, and maybe it's just added to this report just as an update thing. And then as it gets, then you'll have the public meetings. So that's at the point where you'll get more feedback than anything, is when you have that public meeting, right? And to see the direction the city would be going. Is that usually, Andy, the course it would take, right? Yeah, okay. Okay, so it sounds like that's figured out. Okay. Anything else? Does anybody have any questions?
I have a question, not really exactly related to this, but a question I would like to ask in case there's something that I want to bring up on February. I guess if a commissioner was to have an idea that things could happen in the community, or is something that would be beneficial for the community, that relates the zoning or our policies, what would be the right process? Would I go to Andy to share the idea and hear what he says? Would I go to the planners? Would I share it on a work session? How does that work? I would love some direction. Thank you.
I guess, Andy, I know every city's different. I don't know how you would like to do it. Some of my meetings, at the end of a planning commission meeting, there's like new business, and maybe a planning commission will say, I would like us to look into a dark sky ordinance. And then the administrator, because Andy directs the work, he'll take down and then he'll say, okay, well, I'm going to direct that for the next meeting. That's appropriate. I mean, I'm sure Andy will take your calls as well. Not in the meeting, but usually that's what I'm used to. And I don't want to, Andy, you could tell me what you specifically in your city.
I like that. I like that approach. It can either be one-on-one or it could be in the meeting. I think it's, if it's a bigger idea, if you would, it probably makes sense that it come before, be brought up at planning commission, and then everyone has the benefit of hearing that. And then it can be, as you just suggest, scheduled at an upcoming meeting. That kind of gets back to the purpose, I think, of the February meeting in part, is to talk about work plan, ideas of planning commission, what are the priorities, what are things we should be working on, what are things we can forget about for now, that sort of thing.
Yeah, and it's not, thank you, Andy, that's usually what I'm used to. It's Ursula, to answer your question, it's kind of like a minute conversation. I usually tell my people, like in the cities I'm the main attorney, I say, bring it up. And then you might say, again, let's say it's dark sky. I don't know. I'm just pulling it out of the hat. You might say that. And then 3 others say, yeah, we actually would like to see that. And then Andy goes, okay. That means that I think we should direct staff to put that on an upcoming meeting. And that way you have buy-in of the commission. It's usually, like I said, it's a very quick conversation at the end, new business. Doesn't need to be like a formal on the agenda. It could just be at the end of the meeting. Oh wait, I wanted to see if look into this.
And we do that at city council meetings.
Yeah, I figured that's what usually I'm used to it.
Now she has me curious. What's her idea?
All kinds of ideas.
Oh, we have a lot of ideas. It sounds like, to Andy's point, that's the purpose of this next meeting in February, and that's what the planners had said. So,
thank you, guys.
Okay. Any other questions, anybody? No. So we're good?
So.
Okay. Can someone answer my question about how come that thing's so high down there? Or is that inappropriate to ask at this meeting?
I'll look into it further. The application for that building wasn't a final development plan, as best as I can tell from the files. It refers to was a location and extent review, and normally that means that's 10.
Well, no,
21.
But you guys remember, because it's the county, we couldn't have any say, and they're exempt from our rules.
Right.
So they can do whatever they want down there.
I thought we passed some contingencies on it. I know one of it was how to pull in and pull out. And I know there was some concern with the homeowners there with the height and stuff like that. I thought that might have been a contingency in there too.
And
I don't remember.
It was like our recommendation, but it wasn't binding because they're from the county.
right, I understand that, but I guess I'm curious as to, I don't remember what we did. It just seems awfully, awfully tall.
It's very tall. And we lost, by the way. I mean, Cindy,
Yeah.
I
Cindy
remember
knows the
this whole
answer.
conversation. We lost. All we had was the ingress and output. So we lost on that
Yeah.
conversation. So
I
sorry.
think Andy had a comment.
What I was going to say is, let's have Mike research this and bring back to the next meeting an update on the project and specific
Okay,
what some of those conditions were. 'Cause they were recommendations, and we were limited as a city under state statute what we could require the county to do with that project, as you'll recall. But I think it would be appropriate to have an update brought back to the next meeting. And
that'd be great. Okay.
Just a quick question, Andy. How are we going to be affected? School
Oh.
district, does the county have anything to do with that? Are they going to be able to dictate to us what can be built there?
Chuck, you cut out just a little bit, but are you talking about the school district properties?
Yes. Or is that tied in with county control?
Well, the school district is separate. Why don't, we'll check into that as well. Nina and Mike and I will check into that. That's a great question. I don't know if the school district has any similar authority that the county exercised with the clinic. And is that the question you're basically asking?
We'll check on that. School buildings, a school building itself is not subject to local regulation. Essentially, that authority exists at the state, and it goes to the extent of they use state inspectors rather than local building inspectors when they're under construction. So we'll check what happens if they do something other than a school building. Does that change the circumstances? So we need to look
Yeah.
into it.
I would think so.
But with the Gold Digger Field, let's be clear that they have an option on the table. They have 120 days to exercise it. So it will no longer be owned by the school district. They are selling it to a third party.
Right, so it won't
Then
be
that
under.
wouldn't apply.
Yeah.
What Mike had just said, yeah, it's only for like school buildings.
Nina, perhaps if you don't, unless you wanted to speak to it further right now, let's check into that because there are other parcels, school district parcels that aren't under contract right now. And maybe this is something we need to focus on or be aware of if there are some considerations with how the school district might use the property going forward.
Yes, if it's school buildings, but yeah, we'll get the specific answer. Yeah.
Right. Well, I mean, there is the proposal. There was just a study done recently by the school district about the feasibility of moving Carlson Elementary from its current location into the former middle high school building on 103.
Okay.
So it might be good for us to be all a little more informed on that. What, if any, considerations might there be?
The exact parameters. Yeah, I hear you. Definitely.
Exactly. Thank you. Yep.
Yeah.
Is that what you're looking for, Chuck?
Yes, it is.
All right. We'll bring that back at our next meeting on February.
Okay, thank you.
Sure.
Okay, I'm done. Is everybody done?
Everybody's.
All
good.
right. Good night. Thank you,
Good
everybody.
Good night.
Thank you.
Thank you.
everybody.
Good night.
Night.
Bye.
Good night, guys.
Night.